Right, are you Jameldrin
Yes.
Willridge? So we're here. Mr. Willridge has he's on probation in 3 cases, 18-28743, 28744, and 30139. And then there's a new offense of burglary of a habitation in cause number 25, DCCR 1804. And there was an agreement that was reached, and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between, obviously, when he pled and now, which required me, I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay, so where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason if those allegations are true, that Mr. Wilbridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last month, it was primarily, obviously not knowing that was going to happen in Chambers County for the restitution in the burglary. Because
Right.
we all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
and Judge, only thing I can say in that regard is that, you know, of course, I've dealt with him for a long time in this situation, and, you know, he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when, of course, when the whole bond situation occurred. But of course, he turned himself in, you know, did what he's, you know, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
no, it doesn't. And I guess, I mean, you guys know, I mean, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed. And
I mean, the only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
And that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out. Right. I mean, they've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can.
Okay.
So that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I would do see, I guess, where if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously, probation, I value your opinion, and so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple opportunities and what else going on. So I don't.
we're also going to go through, we can do it. I don't know, there probably needs to be amended motions on those 3
To add those.
to add those allegations, and I'm not going to just sign a dismissal on those motions. I want to go through each and every allegation of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess, any type of hearing done so that we can get those new allegations in the hearing, in the motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that
Okay.
promise with.
All right, thank you. Go back to the bailiff. Good morning. Are you Quentin Sells?
Yeah.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial, and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the competency.
Right.
This section is incredibly important because it shows the difference between punishment and competency in the legal system. A defendant cannot legally stand trial if they are mentally incompetent and unable to understand the proceedings against them. That's why the court keeps referencing competency restoration programs and psychiatric evaluations. But here's the major issue. The county apparently doesn't even have an outpatient restoration program available. So the judge is left with very limited options and ultimately orders inpatient treatment instead. This is where criminal law and mental health law collide in a very real way. And notice how even the prosecution hints that if competency still isn't restored later, they may need to reconsider how these charges move forward altogether. These are the kinds of courtroom moments that are far more complicated than people realize from the outside.
Mentally competent with firearms.
Right. I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of, so anyway, take a look at it.
Yes, Judge. I think there's another way we can go
Okay,
with this.
I agree.
Next time.
That's fine, Judge. His priors make him habitual by law, but he didn't receive even half the time he is on this case
Okay.
on those.
All right, so are you Donald DeRusso? And will you find waive the formal reading of the indictment?
I will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count 1 only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You go back with the bailiff. Oh, wait, and I am making an affirmative finding of a deadly weapon. All right. You can go back with the bailiff. Good morning. Are you Avriana Dorsey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, sir.
Ms. Dorsey, in cause number 26, DCCR 0756, you're charged with a first-degree felony. You guys marked off second, but is it a first?
It is a first, Judge,
With y'all's permission, can I change that
Yes, ma'am.
admonishment?
because it's burglary with
With intent.
the aggravated assault.
So you're charged, Ms. Dorsey, with a first-degree felony offense of burglary of a habitation with the intent to commit another felony, aggravated assault. And that's from April 11th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year deferred probation fine.
We didn't really discuss fine, Judge.
Typically, there's going to be a fine of $500. I'll look at that at sentencing. Also, part of your agreement, it looks like, is that you're going to enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Dorsey is not competent?
No.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing.
Okay.
Right? You can go back with the bailiff.
Judge, I think we've agreed if it's the court will accept 8 on Mr. Harrison, we can
Yeah.
call him back up.
All right, Kenneth Harrison, thank you. Okay, we're back on the record with Mr. Kenneth Harrison in 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement, and if you come up with some other agreement.
Yes, sure, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding, and is that your agreement?
No.
And so, with everyone's permission, can I make that modification on the agreed punishment
Your Honor, he
recommendation?
said no.
You said no?
Yeah.
Oh, I thought he said yes.
I said yes, ma'am.
He said yes.
I heard it wrong.
Sorry about that. It's been scary.
That's okay. So, can I make that modification on this document?
Yes, ma'am.
Okay. So I have here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis?
No.
Do you fully understand all the documents you signed?
No.
And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand? All right. Good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody. So on these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a question about whose weapon it was.
Because this is the second MTRP that has to do with,
Well, the first one was dismissed because the only violation, allegation was that he possessed a firearm and felon possession of a firearm, and he had been on deferred, so he wasn't.
right. And, but still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Reddo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on 0 tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to, it's going to be a violation. And it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you into trouble. Right. Okay. You can go back with the bailiff. Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the 3rd-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a 2nd-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a 3rd-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered.
This courtroom session was packed with major legal warnings, plea agreements, competency rulings, and repeated second chances that may be running out fast. Across multiple cases, the judge repeatedly emphasized accountability, especially when it comes to firearms, probation violations, and violent offenses. One defendant received a deal the judge openly described as a great deal, while another was warned that even being near a firearm again could immediately send him to prison. At the same time, we also saw the court carefully address mental health and competency issues, showing how complicated these cases can become behind the scenes. The overall message from this courtroom was loud and clear. Opportunities exist, but patience in the justice system eventually runs out. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Be ordered to.
No, I'm sorry. I don't know that it was the intent of the state to have a total $3,000 fine. I'd be willing to waive the fine on two of those cases and just have.
So a $1,000 fine in, let's just put it in 0265,
Yes.
and there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment, be on that mental health caseload at the probation department?
Absolutely.
State tenders number one in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
All right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes, ma'am.
Then I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation can do a pre-sentence report and possibly get that assessment done, or at least partially done, so that we know exactly what you need when you are released on probation when we come back for sentencing. Okay, you can go back with the bailiff.
Thank you.
Thanks, sir.
David Hale.
Yes, ma'am.
This is 26 DCCR 0106. Mr. Hale is charged with aggravated robbery. And Mr. Lewis, what is the announcement?
Judge, we'll ask for some additional time. I have spoken with Ms. Mofino about this situation. I understand that the state may be looking to either amend or the charges may change on this, but I do need to speak with them more about his criminal history and everything like that, how that affects him as far as that punishment range.
All right, so I'm going to do one more reset. Obviously, if there's any type of
Judge, I think the case is more appropriately implemented as an aggravated assault. I asked Mr. Lewis just to speak with the defendant in the hopes that we could resolve something absent having to do that. At the next setting, I need to do that. I can have it done in a week.
okay.
Or I can go ahead and do it.
I'd rather you guys get that figured out before, so we don't have to
Okay.
reset it at that point,
Right.
if possible. So talk with your client, talk with Ms. Malfino, and if that's going to be something that's going to get worked out, if you can do it before the next court date, then
Sure, it doesn't change the punishment range or anything,
Yeah.
obviously, but it makes more sense to the facts, which might make more sense to.
sure. Okay, sounds good. We'll reset it.